Good evening, and welcome to another League of Women Voters educational program. I'm Catherine Bealey, and tonight we'll be hearing from a distinguished panel on the subject of what we typically call sunshine laws. Joel Campbell from BYU's Communications Department, Eric Peterson from the Utah Investigative Project, and David Reymann, a First Amendment and media attorney, will help us understand the laws surrounding open meetings and public records. Our three presenters will engage in an informal discussion, which we hope will help the public understand your rights and requirements as you navigate these laws, especially with the legislative session coming up. I'll be monitoring the Q&A section, so please add your comments and questions there. With that, I'll turn this over to Joel Campbell, who will explain just what these laws are. And by the way, this webinar is being recorded. Joel?
Thank you, Kathy. I appreciate it. I'm going to show, I just have a few slides to show. I want to make sure that, can you see those now? All right. I'm going to be specifically talking about the Utah Open and Public Meetings Act, and others will be talking about GRAMA, the Government Records Access and Management Act. There is a link to these slides. It's bit.ly UAMPA, for the lack of a better acronym, but that should be access to everyone to look at those. I just want to give a quick bit of history, and since this is sponsored by the League, the first law in Utah to look at open meetings was enacted in 1955 and really had no teeth to it. And everything that this government wanted to do, they just simply held an executive session, and it really wasn't fun. And then finally in 1977, Genevieve Atwood, after 3 efforts to pass earlier bills, finally was able to get a bill through the legislature it's kind of funny to think about it. Right now, the only thing that there were the exemptions would be labor negotiation, litigation, and some personnel situations. So there was like 3, but it's grown immensely since then. But I thought it was interesting to talk about this. And at the time, the Salt Lake Tribune actually editorialized against this bill because they said it was too weak. But anyway, that's how we started this game. So I just want to give you some history and some red flags. I thought this might be the best way to talk about it. During my time as a reporter and kind of someone who watches this law, I remember back in the 90s, probably the Utah legislature had a big meeting to talk about gay clubs on high school campuses. And they closed the meeting. Eventually, it went to court, and the court ruled that they had illegally held an illegal meeting. Back in the 70s and 80s, town officials would often meet in the cafe across the street from City Hall to finish talking about what they thought they couldn't talk about at City Hall. And there was even an instance where some of the people would meet at the local church and talk about city business so that the other folks couldn't listen in. As a reporter, I remember covering the 1998 Olympic bid for Salt Lake City, and we had this group that was called, it was Olympic Site Committee, and they came up with this novel idea that they were going to have a closed meeting on the tour bus that's looking at all of the possible potential sites to host Olympic venues. And the press demanded that we be on the bus, and they said, oh, that's not going to work. So they provided a bus only for the press, which was a terrible overkill. And all of us decided to drive our own cars because we didn't want the public paying for a bus where there was 4 reporters on, or 5 reporters. Also, be careful of attorney-client privilege. That's often used. And I don't know if David wants to talk about that later, but there is sometimes when they'll say we need to go into a closed session to do attorney-client privilege. That's not necessarily among the reasons to close a meeting. They probably ought to have a better reason than that. This last week ago or so, I think we had an instance where the new partisan state school board used the political caucus language in the law to close or to go to lunch together. That's a new one. Originally, the political caucus language has always been intended to apply to political caucuses at the legislature. This new move, as some of these bodies become partisan, is a new concern. Stealth agendas. The law says there should be reasonable specificity. A lot of times, I've been, as a reporter, I've gotten an agenda and it says new business, old business, minutes. I mean, it didn't have any. So they really should, the agendas are required to have at least some specificity so kind of when you need to show up and chip in. There's also boilerplate closures. That happens almost every place that I still see today. Provo City, Utah County, still have closed session. It's on there no matter what. I guess that's okay, but it seems to me you really shouldn't put it on there unless you need to. There's nothing I can do about it other than complain. And my favorite story is I was covering the Board of Regents when they were selecting a new University of Utah president. And the Board of Regents really didn't want anybody to find out who their selection candidates were. So they called an executive session for an unspecified time and an unspecified location. And that's when Bernie Matchin, a long time ago, came to the University of Utah at an unspecified time and unspecified location. So nobody knew that they were interviewing them. Actually, the Attorney General and others, kind of said that was a bad idea and said you should redo it. Sometimes I know that when I covered Salt Lake City, they had the committee of the whole meetings or work meetings. Be careful about those. There are open meetings as well. The thing I was concerned, I was covering Davis County and covered a small town called Syracuse. You probably heard of it. They have this blanket personnel closure. They had a very controversial parks director who was under fire, and they said, we're just going to close it for personnel. Well, the law says that you should talk about the character, competence, and mental health of an individual. In this case, they ended up talking about the whole problems with the Parks Department, including funding and restaffing. That's not part of that narrow definition. So be careful about that. And I do recall in Draper City, they had a very controversial police chief, and they went into closed session and fired him, and eventually went to court. The remedy for this is that you do go to court, and the judge can look in camera or can look at the minutes or look at hear the tape or whatever from the closed session and make a determination if it was properly closed. And in this case, the judge said, yeah, this should have been open, or at least most of it should have been open. But the remedy is not too stiff in Utah. They basically just had to go into open session and do it again. So those are some of the things that, and the last is, Kathy's going to remember this. Back in the day, we had a little card. We probably should reinvent a card that gives it to all the public members where you can stand up and publicly challenge. I became a frequent challenger at the Davis School District when I covered it, because I would ask them, well, what are you closing this for? And why are you doing it? And when are you going to come back out in public? And I made a nuisance of myself, but they actually started responding in more positive ways about how they were closing their meetings. So I'm just going to, these are the kinds of things, as you know, that are open. I'm not going to spend a lot of time with that. A meeting is when they're talking about the public business and they're discussing, receiving comments, and they're acting upon a matter which the public body has jurisdiction or advisory power. And the biggie also is, do they spend money? Are they voting on spending money? That absolutely must be discussed in an open session. And so I'm just going to put up the exemptions. I won't spend a lot of time on here, but the first one I mentioned is personnel. Notice that the tight language there is a character, professional competence, or physical or mental health. Strategy sessions to discuss collective bargaining. If there's a lot of school districts discuss collective bargaining with the unions about wages, security, personnel, devices, and systems. When I was covering Davis County, they went on strike, Davis School District, and they did hold a closed session about security and so forth. Investigative proceedings, if there's criminal misconduct and they want to talk about that, they can. Trade secrets, commercial information, that's kind of a newer addition to the exemptions, but some people have worried that trade secrets might be exposed in some of these sessions. And then we have the pending or reasonably imminent litigation. So I always tell my students, if they stand up and say, I'm going to sue your pants off, that's not reasonable imminent litigation. It's actually something's been filed at the courthouse or something's going on there that shows that it's imminent. And then the biggie, which you can go into the law and read more about, is strategy sessions to discuss uh, purchases of property, exchange, lease, or sell. And the key concept here is if the public body is going to be financially somehow underbid, or people know about the school district selling land and the public loses money. That's kind of the bright line. And by the way, no meeting must be closed, so they could open up any of these. I'm going to kind of leave it. Let me just go here. A lot of this is I'm going to go ahead and stop sharing and just leave it at that, because it's a great little introduction. But if anybody has specific issues or problems, I've kind of generally went over the requirements. Oh, one last thing is the notice requirement, and that is, unless it's an emergency session, in Utah, the law is that it needs to be a 24-hour in advance notice, and they have to post it on what's called the state um, public notice site. And anybody in the public, if you want to follow Sandy City, Salt Lake City, Utah County, you can go on and sign up, and it will send you an email every time one of their agendas is produced. And so that's one way that you, as a citizen, can track the agendas. It's a pretty good system, and so that's one way you can keep on top of your local government. Kathy, I'm going to hand it back to you for anything else.
So how do we know what goes on in a closed meeting? They are supposed to take minutes, is that correct?
Yes,
Do-
unless it's about a personnel issue. And then there's this fancy affidavit language, which I have always opposed, but it was a compromise where they have to sign an affidavit that says, we only talked about, the character and competence of this individual in this closed session. Now, a lot of the places now not only take minutes, but they record it. That's kind of a matter of course, and that can be helpful. It is a protected record, or you can't get it. You under grandma, you couldn't get a copy of it. But if somebody did challenge it, if I went and said, I think that they violated the law, the judge could then take it and listen to it, or look at the minutes, or listen to it in camera, meaning he's in secret, and then he could determine, well, 90% of it should have been open. This 10% should have been closed. So there is that option, and there is some misdemeanor fines, but they've never been used. And the only thing that's really ever come of that is that they've had to redo it in open session.
Well, I will say it is hard for someone from the public to stand up and say, why are you closing this meeting? So I think we'll now go to Eric Peterson, who's had a lot of these issues, and he knows how to tell people they need to come out of closed session and tell him the truth. Now, Eric, I'm going to you now.
So you want to talk, we're going to switch to grandma more now? Is that the plan?
That's
Yeah.
Yeah, this is a good segue to a couple of things I wanted to say about sort of remedies about open meetings before we
Yeah.
go to
Yeah, we
Eric.
should do that.
It
Yeah.
kind of dovetails with a couple of things that Joel has just said. Um, it is very important to object when you are in this situation, because the language of the statute says you have to have been denied a right under the statute. And you could argue, well, I'm denied a right just as a member of the general public, even though I wasn't there, because I don't know what happened. That is a really tough argument to make. And so this goes to the legal concept that some of you may be familiar with of standing. And in the Open Meetings Act cases that I've been involved with in the past, we have always had reporters or other plaintiffs who were in attendance at the meeting. And whether you have to object or not is an interesting question, but at least if you are there and you're deprived of seeing what happens, then you're in a different situation really than the general public, and that probably is enough to get you the ability to do something about this. If you are in that situation and you object and they go into closed session, there are a few things that the law does allow you to do if there has been a violation of the Public Meetings Act. You can sue to void whatever action they took. and that will undo essentially what had been done. There is a short time limit on that. You've got to do it basically within 90 days, and it's even shorter if it's issuance of bonds. So if you are in that situation, you need to act quickly. But you can also sue to compel a public body to comply with the law, or to keep them and join them basically from violating the law. And that also can be an effective remedy if you've got a public body that is repeatedly doing the same thing over and over again, and you can go to court and say there's a pattern that violates the law. And you can but a lot of times that it can come too late if it's already happened. And the other thing, like Joel said, is that one of the things they can do if their actions get voided is just come back and do it again. Although I would say it's not a useless remedy, because that is kind of the point, is to have them do it in the open. And then you can also sue to determine the applicability of the act if there is a legitimate dispute. And sometimes that, in my experience, often is the most common thing, although people usually don't just sue over that, because there's a dispute and they're getting told by their counsel, you don't have to do this in the open, and citizens say, we think that's wrong. I will say, one of the only sort of things with BITE in the statute is that you can get your attorney's fees if you prevail, and that is somewhat of a deterrent against entities that are being cavalier about complying with the law. That's the last thing I'll say about remedies, is that these would be hard cases to bring pro se. So if you are at the point where you need to go to court, it's probably something that you want to talk to a lawyer about, or if you're an experienced journalist, you may not need to do that. But if you know ahead of time that this is going to happen, then there are things you can do ahead of time to try and prevent the situation where you're trying to undo something that's already been done, and that largely involves contacting a member of the body, especially if it's one of your representatives, your city councilman, something like that, or the municipal attorney who advises them, getting in touch with them. I've done that quite a bit, and say, write them a letter or get them on the phone and say, this is the way we interpret the act, and I think that they need to have this in the open. I mean, sometimes these bodies just need education about what their duties are. There's a high turnover on a lot of these government agencies of especially elected representatives, and they just need to be educated. But I'll just give you, and one to Joel's point, we had an issue you may all remember with Natalie Klein, who was facing discipline by the Salt Lake School Board, or the Board of Education, some months ago. And they were planning to go into a closed session to discuss what they called her professional competence, if you can call it that. And we wrote a letter to them ahead of time saying there's a significant amount of public interest in what is going to happen, and we recognize that you probably have the right to have this discussion behind closed doors, but in the interest of restoring, public faith in the Board of Education, we encourage you to do it in the open. And we didn't carry the day on that, but that's the type of thing, if you know in advance and can do a little bit of planning, that you may get a sympathetic ear in someone who says, well, I'm not going to vote to go into closed session, because they procedurally, like Joel mentioned, they have to start an open session and then they have to vote to go into a closed session. And it's got to be, I think, 2/3 of the people on the entity. And so if you can do a little bit of advanced work, then you may be able to get a more effective result than having to hash it out in court after the fact.
And I think Joel said there is nothing that says they have to go into closed session. Is that right?
That used to be true, and I was kind of chuckling as Joel was listing his reasons for closing meetings, because I think just in the time I've been practicing law, which is unfortunately a long time now, I think the reasons for closing them have tripled. And every year it seems like the legislature adds one. So one of the things they've added just in the last little bit are these, Joel is technically right, but there are certain types of entities when they're discussing a particular type of thing that have to close their meetings. But if you're not one of those entities, the reasons that Joel was listing, that's right. Like they can choose, you could deliberate behind closed doors. The State Records Committee, for instance, could deliberate behind closed doors, but they choose not to. And so that really is a matter of just trying to get, your representative or public officials who say that they're committed to transparency to put their money where their mouth is. But other than that narrow category, that's exactly right.
Yeah, and I should qualify that by saying, yeah, they created just a few years ago a few ethics bodies for the legislature and for other elected officials. And yeah, yes, they did say that they should be in a closed session. So yes, that is a good point.
Yeah, and it's a couple new ones, like the Colorado River Authority didn't want to have to, say anything to the public about how they're divvying up our water. And it's one-off things like that that just have been appearing in bills up at the legislature that is just sort of building this category of off-limits stuff. But the general principle, and this is important to keep in mind just about this act in general, unless you fit within one of these reasons to close a meeting, it is presumptively open. And that is an important kind of bedrock presumption, just like grandma, that Eric will probably talk about, that the presumption is that the public has a right to see their business being done. And you have to fit within one of these statutory exceptions to deny the public from seeing that.
So I think it would be a good idea, as Joel said, to have a little reminder that we can put in our wallet or something when we're trying to object. Could either you or Joel talk a little bit about the school board and what's happened recently with the Open Meetings Act?
I would defer to David because only thing I know about is what I read in the Tribune, but maybe David has more information.
Well, Joel probably knows more historically, but there is a definition in the act that says what a public body is and what a public body is not. And the Open Meetings Act only applies to public bodies. And when they enacted the act, the legislature didn't want their caucus meetings to be something that had to be open to the public, even though, because we live in a supermajority state, they probably had a quorum of the particular legislative body just in the Republican caucus. And so they put an exemption in there that says a political caucus or a political group, whatever that means, or a political party is not a public body. And that I have not dealt with that for a really long time. And it used to be, it's always ever come up in my experience at the legislature that was sort of what it was interpreted. Well, you may know that the school board now has partisan elections, and is it the Board of Education? They now have, I think it's 2 Democrats and I can't remember how many Republicans, something like 11. And they have now called themselves a political caucus, and they are meeting in secret to presumptively talk about Board of Education business and do behind closed doors what they should be doing in public. And it's a really dangerous expansion of what it means to be a caucus, because if it just means 2 people affiliated together in a political party, then pretty much almost anybody in Utah with people who are politically affiliated could get a majority to get together and evade all the requirements of the Open Meetings Act just because they say we're a part of the same party. So it's a relatively new thing, and it's something that I'm glad the Trib reported on. And it's something that everyone should be keeping their eyes on, because if that's really what it means, and it's not just the legislature, then it's a pretty big gaping loophole.
Okay. Well, we have been talking about open meetings. Of course, there are also records that many people would like to get their hands on. I know Eric has done a lot of work in this area, and maybe he could talk to us a little bit about grandma, the law. And I think you were both talking about fees and excessive fees. So Eric, let's move to you.
Yeah. Thanks for having me. I was thinking about what I like to kind of say about grandma. I mean, I teach about grandma, I do trainings about grandma, I file too many grandmas. But I wanted to kind of stick more to about, I think, strategy. And understanding your rights on some fundamental levels, but David is such a legal eagle in this area. He can really get into a lot more specifics about the law. But I had really wanted to just kind of talk about, um, like good ways that like you should be using grandma and kind of like basic things to like be on the lookout for. And I some of the things I like try to like tell people about grandma is that like you shouldn't be intimidated by the process of filing a grandma. It should be a simple thing. It should be a simple way to just find out how your public taxpayer dollars are being spent. They really are your records, even if they're in the email inbox of the mayor or somebody on the city council or whatever. It's not a thing to be intimidated about, although like I've had plenty of grandma fights that have been long and protracted. I went to the state records committee and then we sue over them. And those can be really intense and worthwhile battles, but most of my grandmas are just me curious about something and then essentially writing an email about it. And I think that's the way a lot of people who are not journalists should also be thinking about it. I've told this story before, but like I said, like I've been in like some big kind of records battles, but I remember there was a time I was working at the City Weekly, and I like kind of showed up to the office like on a Friday, and it was my deadline. I had to turn in a story. And while I was like on the tracks train to the office, I found out that this story I was working on had totally crapped out on me. And I had to do something entirely new. And I was like, I don't know what I'm writing today. And when I got into the office, and I saw like I had an email. It's like, oh, you got this grandma back. And it was a grandma I had completely forgotten I'd even filed. It took me like 2 minutes. And it was a grandma asking Salt Lake City, who gets free parking at the airport? And it took just like a couple minutes, and I got back a list, and I could see, like the city lobbyist, and then Kurt Bramble for some reason. I was like, oh, this is a fun little story, and it kind of saved me. And it was a grandma that was like really easy to do. Um, and so like I think like people should get like comfortable with it. And I think people have become more comfortable with it because I feel like there are more grandmas being filed. But
So,
that being
Eric, I'm going to stop you for a minute because many of our audience don't know what grandma stands for or what
right.
So if you could explain that and then tell them, there used to be forms that you had to fill out. You're now saying you can just send an email, but if you'll take a few minutes to explain what grandma is.
Yes, good interruption. Thank you. So the Government Records Access and Management Act governs public records requests. I file a grandma. I'm just filing a request with a government agency of any kind, really, and I'm asking for records that should be public. So that could be emails. That could be investigative reports. That could be text messages, budget documents. The general rule of thumb I always like to say is that like if public money is involved somehow in the production of something, if there's public money attached to a document, then you should be able to get that document. Now, you might not always be able to get it when you want, but that's the general rule of thumb, right? Like I'm just asking, I'm curious about something. I think an agency has documents about it, and I'm filing a grandma request to receive those documents. One thing I was going to say about, so like you should not feel intimidated about filing a grandma, but you should be conscientious of how you file a grandma. And there's a lot that could be going into this, but like I think for like today, like I like want to like focus on like a couple strategy wise like things that like I always try to like I evangelize this strategy, which is to be very specific and to be very polite. When you file a records request, like you want to be able to make the request as easy as possible on the records clerk who's going to have to go around and gather up all these records. So like if there's something that happened, like you want specific dates, locations, names of people if you can. If you're looking for email communications, you want to like a good time frame. You should try and restrict like who would be receiving and getting emails. I remember when I first started work at the City Weekly, I tried to, I did a grandma request to the Attorney General's office where I said, emails about this company from all employees, and so then that turns out to be hundreds of employees. And they're like, okay, well, we can do that, but that could be pretty expensive and time consuming. I think you can argue that's a whole other thing. But like you want to, in general, be thinking very specifically about not being, saying like all documents about this, all this, any that, like trying to be specific as possible makes your requests more targeted and more likely to be fruitful. The other thing is like being polite. Like one of the like I've been encouraged to see more people file records requests. People going to the state records committee and arguing against denials of records. I do get concerned because I feel like there's some people who, citizens and journalists, that will take grandma, and they file a grandma request, and they start to feel like they're a lawyer, and it's like they're suing the government agency. Like they kind of like take an aggressive stance where it's like you must provide this and this and this, and like we act like we're seeking discovery in a lawsuit. And it's interesting because that kind of aggressive stance, there is a school of thought that says like that is the way to file grandma requests. There's this guy, I think David Collier, and he's a really good guy. He's like really smart about open government, open records. And I've gone to a couple talks he's done at like investigative reporters and editors conferences about accessing records. And but he's actually done like a study he did where like he sent out grandma requests. Well, they weren't called grandmas because it's like in Arizona, but a similar kind of statewide, public records request, and put out these requests and had like one that was more neutral language and then one that was kind of this more aggressive kind of posture talking about you must do this under the law, and if not, there's these penalties. And he found like the aggressive kind of posturing actually got better responses. I'm really paraphrasing his study here. And the thing is, like, I've never really trusted that approach still, because I think when you are requesting records, you should be thinking not just about that request, but like how you might be dealing with this agency in the future. Like you should be thinking about if I come out the gate like on the warpath, I don't have as much wiggle room, I think, to like kind of work with a records clerk or an agency and to get them to maybe just help point me in the right direction or say, actually, you should be requesting this record, not the one you asked for in your request. So that's why I really like to say like being polite and being specific is really important. Like when you are at an adversarial relationship with a government agency, like it's the worst because it's like the law will still be followed begrudgingly until it's not, and you have to like get a lawyer like David and like take it to court. But like everything is so much harder. When I used to hound the attorney generals, Mark Sherliff and John Swallow a while ago, my relationship was so strained with the AG's office. I remember once filing a grandma where I said, I would like to request these documents. And then, weeks went by, I never heard back from them. And I reached out and I was like, how's that grandma request going? And they're like, oh, we didn't know that was a grandma request. You said you would like to request those records. We didn't know that was the official request. And it's like, give me a break, But I was also younger in my career, probably more aggressive in like how I was like, going to war with these agencies. Like, it is much better to realize that the person who's probably going to gather records for you is not your enemy. They might not even care, what's going on at their agency. Like if you can like have a dialogue with them and always say, this is what I'm looking for. I don't know if you like want to talk about it. Can I clarify it? Maybe you can help me out. Like I don't want to make more work for you than is necessary. Having a dialogue, some rapport going with like the records clerk is something that will help you out. Because I've done stories in the past where, like I have like wrote like a story talking about how the Utah OSHA is regulating workplace accidents and talking about how little, fines companies were getting when people died on the job. And I had to do like some pretty big grandma requests with that agency. And I remember the story was coming close to deadline, but I needed to get a grandma expedited. And even though like I think the agency knew this story was not going to work well for them, the records clerk, when I asked her, was able to expedite a grandma request to get it to me sooner to meet my deadline. When under the law, there's no real requirement that they expedite any kind of grandma request. I don't think I would have got that if I had been come off as like I was trying to sue OSHA instead of me saying, like, hey, I'm just trying to get records to tell a story about your agency and what it does.
So is there no time frame that they'd have to get back to you once you file a grandma request?
No, so that's just my kind of general strategy. Let's talk about like a few key things I think that anyone who's getting started with this should know. I think like one of the big things I see with people who are new to grandma is they file a request and they get ignored and they think that's it. And I think people really need to know like you've got 10 business days and then you're supposed to get a response. If you don't get a response, it is a de facto denial. Then you can appeal it. You can appeal it up to the next level. That gets denied, appeal it up to the state records committee and keep moving along. But knowing that, I think is a really key thing because I think there's some agencies that just hope you go away and so they don't want to respond. And so going back to that point about like not being too aggressive, like there's a polite way to say, file a grandma request and then circle back, like 5 or 6 days later and say, just checking in. I know we're getting close to 10 business days. I just want to make sure this grandma is coming along. The other kind of key thing that I've noticed that I've seen that's pretty frustrating is that when you file a request, hopefully they respond in 10 business days. Maybe they don't, maybe they do. But whenever they respond, if they do, there should be, in a denial of records, there should be an official response that does like some key things. Like the official response should say, you know what, this grandma is denied in whole or in part because of this section of the code. There's an unwarranted invasion of privacy, or it might cite other sections of code. There's an ongoing investigation or something like that. It should say, but if you're not satisfied with that, this is how you appeal, and this is like your time frame to appeal. The general rule of thumb is like you file a request, there's 10 days to respond. You get a denial, you have 30 business days to like file an appeal. And then, they've got 10 business days to respond and 30 to file. David, correct me if I'm wrong on that. But so one frustrating thing I've seen, and it's happened to me a couple times, but I also occasionally get involved in stories where I meet somebody, maybe they had a crime happen to them, or there's something they've been interested in, and they will show me grandmas that they filed. And I will see the response they get, and a records clerk will send a response back where it's like, okay, these are the records we found, or no, we didn't find any records. But what they don't do is give an official response and say, your record request was denied for this because of this reason, and this is how you appeal. That's really concerning to me to see that happening to just regular citizens, because I don't think they know that they can appeal I don't think they know that if they get one record back, they don't know if the agency has other records that they're just not providing. They're not even saying why they're not. So you need to think about, like, yeah, be mindful of that 10 business day kind of time frame to respond, and pay attention to what the response is. What they say. Did they tell you that there are more records, but they can't provide them? And if so, why? And what is your route to appeal? I don't know. You want?
So this is kind of intimidating for the public. And when you're talking about appealing, why don't we talk a little bit about the Records Committee and what's happening there? People can appeal all the way up to the Records Committee. Who would like to take that one on?
I can talk a little bit about that. Yeah, I mean, it does all sound like intimidating, but like, I'm not a lawyer, and I found that like there are a lot of appeals, a lot of denials that are very actually easy to appeal once you trust in yourself to do a little, even like a little simple Googling. One of the common denials I often see is that they do the right thing, they give a response, and they say, this is why it's denied. Usually they don't say, they'll say because of this section of code, and there'll be 63G-204 subsections, and that looks intimidating. But then you just like copy and paste that in, look up the Utah code, and go, okay, they're denying all of this report because somebody's phone number is in the document. Well, that's one of those times you go back and say, hey, why don't you just black out the phone number and then you can provide the rest of the report? That's a very common thing I see all the time. The agencies will use any excuse to deny the whole report instead of making redactions, which under the law they can do. It is a little extra work for them, but they are also entitled to charge a reasonable fee to do redactions and things like that. Anyway, so like you can find out like what are normal appeals to do, make those appeals. You do your initial grandma, you get denied, you appeal to the chief administrative officer, which is also another person probably heading that agency, or their deputy, get denied again. Then you go to the State Records Committee. The State Records Committee is a really great resource, very uncommon, I think, in the nation, but you get a chance to argue why you think that, like why you were right and the denial of records was wrong. And it's an independent body. There's a media representative, there's like a local government representative. And it's a great resource because they have the ability to also look at the disputed records in camera and decide for themselves. So it is a great resource if you can get in. I don't know if you want to talk about that, David, like the problems, or Joel, that we're having now with them.
And David, how about you? You've been dealing with the Records Committee a little bit.
Yeah, I did. Before I get to that, I just wanted to mention, I don't know if Eric said this, but if anyone is interested in submitting a grammar request, there is not necessarily a form that you need to use, but just Google Utah Open Records Portal. It will pull up a site that covers most agencies in Utah, and you can pick one from drop-down menus. It's very user-friendly. It's designed not to be used by lawyers. And it'll walk you through how to submit a grammar request, and it'll do it electronically. It doesn't need to be a particular form. So I just wanted to make sure that was there. It's a Utah state government website that's sort of over all these agencies, and it's a good way to get started if you've never done it before. The State Records Committee, like Eric said, this whole process was designed so that you wouldn't need a lawyer. You can appeal to court after the Records Committee, or you can appeal to the court after you lose below. And sometimes you might need a lawyer for that, although not necessarily. But the State Records Committee was designed so that journalists and citizens could represent themselves. It's a very relatively informal process. You go before them and you just make your case. You submit sometimes I've seen as easy as just a letter or an email to them just saying, these are the reasons I think this should be released. And it's been a pretty valuable tool because unlike the agencies that you're asking for the records from, it is supposed to be an independent agency. And they have made a handful of decisions lately, a couple of which I've been involved with, one involving Attorney General Reyes's calendar, that have made the legislature very upset with them, just like they're upset with the courts and upset with pretty much any government body that doesn't do exactly what it is that they want done. And as a result, and there's already been a substantial backlog at the Records Committee where we've been waiting months to get a hearing. And I'm not saying this to discourage anyone from doing this, because you really should do it. It's a relatively painless process if it's working well. But there was already a backlog because government agencies have been less transparent lately, in my view. And also, I think there have been more grammar requests that have been submitted. So we're already dealing with a sort of crisis of people being able to get an independent determination of whether records are public or not. And people are appointed to the Records Committee by the governor, and they need to be approved by the Senate, much like you would be a judge. But it's always just been if you're willing to serve on the committee and people are very committed to serving, then there's not the sort of, raking over the coals examination like we would give to Supreme Court justices. Well, the legislature, a couple months ago, they had 3 people who had already been appointed and were just seeking renewals of their terms. The governor renominated them for additional terms, and there are 7 members on the committee. And the Senate, basically, the Utah Senate has refused to approve any of them. And the result is that there are only 4 active members of the Records Committee, which is not enough to conduct any business. So the Records Committee right now is basically paralyzed. And all they would need to do is approve one more person. But my view at least, this is just my view, is that this is retaliation against the Records Committee to tell them if they step on the legislature's toes, there's going to be consequences for the work that they need to do. And we should all, as concerned citizens, be very concerned about that, because it isn't the sexiest or most front page story, although the Trib did do a story on this a week or so ago. It seems very administrative, but it is basically the tool that was put in place to allow citizens to vindicate their rights to get public records when agencies tell them to pound sand. And we need to have a functioning and efficient Records Committee. And so if you have the ear of people in your community or your elected representatives, this is something that hopefully it will get resolved soon. But as far as of tonight, I haven't heard anything about. I think the governor has nominated at least one more person, if not 2. But I don't think the Senate has done anything on it. And then that's really unfortunate. It's kind of an unfortunate trend recently about the legislature not being responsive to the people that they're supposed to be representing.
And how expensive is this whole process? I mean,
It's
Eric,
it's not expensive, Eric, and I don't think there's any filing fee at the Records Committee at all. It's really just a matter of time, just taking the time to keep doggedly pursuing records. Eric can correct me if I'm wrong, but I don't think we've ever paid any fees.
Yeah, for the whole process of appealing and going to state records committee, it's just the time you put in. Going to the state records committee, the schedule can sometimes be hard to predict, so it might mean you spend your afternoon there. But there's not a real cost like that. But on that point, though, something that is a concern that I think we hear more about is charges for a records request. Now, we mentioned just a little bit before, agency can they can request a reasonable fee for gathering and preparing records, and it's not supposed to exceed the hourly rate of the lowest paid employee qualified to gather the records. But I know, David, I think you've got some insight on what we can do about getting excessive charges being quoted. Sometimes I was talking to another reporter today who was saying that They're trying to get data requests and being told it's going to cost thousands of dollars.
Yeah, some agencies are better than others. So here's just some and so that is the only place where it would get, it could be a monetary concern. I think to Eric's point earlier, though, the more specific you are, the better off you are. If you just say, I want every record related to the mayor, they're going to say, we can do that. I mean, but it's going to cost you thousands of dollars. So my suggestions on that, I'll give you just a couple pointers. What the law allows them to charge is a reasonable fee to cover the actual cost of providing the record, the actual one. If you request a record in a form that they don't maintain it, so you're like, they don't have to create a record, but if you say, I want you to compile a bunch of things together into a Excel spreadsheet for me, they can do that, but then they can charge you for additional stuff like staff time. But they cannot charge you, and I have seen this a lot, they cannot charge you for time to review a record to see if it's public. That is prohibited under the statute. And so if you're getting that response, then they're probably not violating or they're complying with the law. A few things to keep in mind. You are entitled to inspect a record for free. And you usually have to do that at the business offices if it's possible to inspect it. But they cannot charge you for going into the office and saying, here's the record that I want, to see. You should, if it works for you, you should ask for records in electronic format. And some agencies, I've heard stories before of them printing emails out and then charging by the page. Just to Eric's point earlier about having a dialogue, I always try and reach out to records officers after I've submitted a grammar request and talk through some of these things and say, look, if it's overbroad, let me know. We can narrow it down. We want to get them in electronic form so that you can just put it on a thumb drive. We'll pay for the thumb drive. You can ask for a fee waiver. That's allowed under the statute, and that's especially encouraged if you're doing this for the public benefit. And another thing that I usually do in my grammar requests is say, I'm authorizing up to $50 or I'm authorizing up to $100 in fees. And if it's going to be more than that, please contact me and we can talk about it. And that can also give you a way to have a dialogue. Because the one thing you don't want, and I've rarely seen this, but I have seen it before where someone submits a grammar request, there's no response. And then they say, we've got all your records, you owe us $5,000. They're not supposed to do that. They usually will just say, well, I'm not going to pay it, and then they don't give you the records. But just head all of that off and have a discussion, especially with agencies that you may think are being unreasonable. They may just not know what they can charge for, or it may be that your grammar request is just so broad that they're trying to gather a whole bunch of stuff that you don't really want. And if you can have a discussion with them about how to do it in a less expensive way, then it can avoid some of those problems.
Yeah, I agree with that. And I know that Kathy's going to share these probably in an email, but I did put up a link to the portal. And I also put up a grandma letter that I use with my students. One of the key things in that is that we were asking for, it was a simple story about specialty license plates based on colleges. And we knew that there was personally identifiable information in the record. And so we said, we don't want that. We just want information about how many University of Utah, BYU, Utah State license plates are by county or zip code or whatever. And they were very cooperative with us as an example. But yeah, by saying, I don't want personally identifiable information, that's not what I'm after. That was interesting. I think if you can do that and just kind of anticipate that. Another thing that's helped me, and I think citizens can do this as well, is just make a phone call even before you file your grammar request and talk to some people about. One thing that I was taught early on in my career was go find, and there's not as many forms you fill out on a piece of paper, but even a form online, that form eventually ends up in a database somewhere. And so you kind of know the fields in there. So you could say, well, you got this form we fill out. I want this information. I don't want that information on the form. And so there is some ways to kind of look at that, but and it could be, a lot of record requests don't end up at the State Records Committee. You can just ask for, and maybe you try out some simple, very simple things. Also, I tell my students to break them up. If there's one that's kind of complicated, fill that out as a separate request. If there's one that's simple that you can do something quicker, do that.
Can I add one last thing to that? This I see more than almost any other problem with people who are trying to do this themselves. And Eric mentioned this earlier, is that one part of the record is they don't want to release, so they just say you can't have any of it. In these conversations that you're having with them, say, is there part of the record you can release? Because that's their duty. Their duty is to release the remainder and redact. Segregate out and redact what's non-public. So do not let them get away with saying, we've thrown some non-public information into this record or into this file, and so we're just going to tell you you can't have any of it. This comes up a lot with police reports and things of that sort, where there may be names of victims, and you can just tell them, I'm not interested in that, so just redact that and give me the rest. It can be an effective tool for getting around a blanket denial.
Don't they say that's going to cost money too, for them to spend the time going through and redacting, and you'll have to pay for that? I've had that happen.
It's a complicated question because the statute's not entirely clear on that. There are good arguments on both sides of that issue.
Okay.
I mean, if the argument I usually make is, look, if it's not naturally information that would be in the record, but something that they've chosen to intermix, and this happens a lot with databases these days, then my argument is, look, you made a choice to intermix non-public information with what should be public records, and that was your choice. And so if you have to incur time disentangling that, that's on you. But I don't think that, at least I'm not aware that there's any clear law resolving that in Utah, and it probably depends on the nature of the record.
I had a quick question. I actually want to ask David about that. So I have had in the past, like, a good experience, like requesting to inspect a record that somebody else had requested. I remember when Mark Shurtleff was running against Bob Bennett in the Senate. Bob Bennett paid almost like $10,000 to do opposition research on Mark Shurtleff, and he paid for that grandma. And then when Shurtleff dropped out, I was like, I'd like to inspect all those records, and got like a good story out of it. But one thing I've been curious about, David, is like, what if they say that in order to inspect a record, they have to redact or cover up some private information? Can they charge you then?
Yeah, it's a really good question, and I don't know that there's a clear answer to that one either. My guess would be that it would be the same as giving you copies, because you're not going to be able to get around truly non-public information they can't release just by going in and looking at it. But it would probably depend on whether you could make an argument that the fact that they are all together is sort of not a natural way that they could have maintained these records in a way that could have allowed inspection, and so you shouldn't be required to pay. And just so everyone knows, just like denials, you can appeal fee determinations, excessive fees, and denials of fee waivers as well. So it's all something that you can get review from. And lately, the State Records Committee has been pretty good on excessive fees.
So if I remember correctly, Eric, you had an issue with emails that you were requesting. You want to tell us that story?
Yeah, just when it comes to, like I was saying before about like trying to be polite with agencies, sometimes you can't predict sometimes like how records will be provided to you. I've had a lot of different kind of pushback, but one funny story, like I had requested emails from the Division of Technology Services for a story, and they provided me, I think it was over 1,000 pages of emails printed out, and then they redacted them. But I remember being like, this Division of Technology Services, you can scan these and send it to me in electronic format, and said that they could not do it. So I had to like go through each page at a time, but they didn't charge me for printing it out, so that was a bonus. But yeah, you'll some people react in funny ways sometimes to your requests.
I wonder if Eric, I love success stories. I just would you be willing just to talk for just a minute about the Cox cabinet conflict of interest
Oh, yeah.
forms? To me, I think for League of Women Voters, this is really important about, cabinet members, their conflicts of interest, and what seems to be should be a public document that you had to go fight for.
Yeah, that was, I mean, like, I still just been head shaking about that, but I had just requested conflict of interest forms for Cox's cabinets, all the heads of, natural resources, workforce services, and conflicts of interest. If you're not familiar with this, I mean, this is basic, like bedrock public record, a public official should disclose, hey, I own this investment, I do this, I've had this job, or I might be doing this part-time, just so, it doesn't preclude them from holding a public position. It just lets the public know what their possible conflicts are so they can judge for themselves if it affects their decision making. Did they make this decision for the public's benefit or for their own benefit? But the Cox's the state agency that handles all these forms denied the request, said they were personal records, and that was a really frustrating experience because I don't know that I've ever had like such a blatant denial. And finally got the records, but it was only I decided like, well, this denial is the story now. And so we did a story in KSL talking about how unprecedented a denial this was. And somebody asked Cox about that at a press conference. He's like, "Oh, when the story came out, I decided we should release them, for the sake of public transparency." Um, and that is, I mean, that's another thing talking about denials and stuff. Like, if like you're really getting serious pushback, we should be telling more stories about the loss of access. Even if you're not a reporter, like if you got really bullied and shut out of records or a meeting or something like that, that is the pitch for the story to media and stuff, and saying like, this is a denial I got. I don't think this is right, and I think we should make some noise about it. And that might help you out, getting into the meeting or getting access to the records.
Yeah, I will say, along those lines, this fight for Sean Reyes's calendar is so absurd in so many ways because it's the most basic. And if some of you didn't follow the story, this was Annie Knox from KSL had asked for a copy of his calendar, and he said, well, I intermix my personal, to the point I was just making, I intermix all my personal appointments into my work calendar, and so you can't have any of it. And we said, that's fine, we don't want any of your personal stuff, just take them out. And they said, no, that means it's not a record. And he also said he didn't want to disclose the locations of places that he regularly went because he thought he was going to get assassinated or something along those lines, or be in danger. And we said, we don't want that either. So the records committee said, we just want official appointments. Just the time that he's spending on our dime as our public official, we want to know whether he's doing his job and what he's doing when he's doing it. And the records committee ordered that released, and they appealed it to court. And most of you probably know the end of the story, which is that we won. The district court ordered the attorney general to release his calendar, and the next day, the legislature changed GRAMA so that all calendars for all public officials from now on are not even records under GRAMA. They're not even records, so you can't even go in and make the argument that the public interest outweighs that interest. So that's the sad part of the story. The two positive parts of the story are that they had appealed that decision, and we were able to reach a resolution with them. And you may have seen over a few days ago that KSL had some reporting on, and will continue to have some reporting on a lot of the calendar entries that we eventually got, because I think the Attorney General's office decided they didn't want to fight this anymore. And then the other thing, to the point Eric just made, is that all three of the candidates for Attorney General in the race, this past race before the election, had committed to transparency and showing the public their calendars. Now, whether Derek Brown was the squishiest on it, so whether he actually lives up to that it is a different question. But these fights, even if they're only ephemeral in terms of what the results are that you maintain, or even if by the time you get the information it's stale or perishable, it can have an effect on other public officials who say, I don't really want to enrage the public, across the political spectrum and look like I am not doing my job. And so sometimes these fights are not just about the records that you're seeking, but more to try and instill in government officials the fact that people care about transparency. It's not just the records you're seeking, but you're seeking to hold government accountable. And hopefully one day, it's like turning a battleship, but we'll have a government that's been more transparent than the last couple years here have been.
So the league may need all of your help at some point. We are not reporters. The league is presently doing a study on the Utah Fits All Scholarship. They're having quite a bit of difficulty getting information about that scholarship. Part of it is probably because the legislature hasn't really created all of the documents, but I think they're going about this as though they were our study group is going about it as though they are reporters. So this will be very helpful to them.
I think that's great. I've heard some, well, I mean, from the get-go of this scholarship, I mean, people kept saying, what's the transparency? What's the reporting? Well, there is not a lot of reporting that you're going to be able to, records aren't even being created. So yeah, it's a real mess.
I will just throw out, I don't mean to keep bagging on the legislature, but just so you know, if you're trying to seek records from the legislature, as opposed to some other government body, it is very difficult. And the reason is because if you get denied by the legislature, it goes to, I believe, the chief administrative officer, which is the president of the Senate or the Speaker of the House. Can't remember if there's an intermediate level of review. But the very last person you can appeal to is basically the legislature's own records officer or records appeal officer. You can't go to the State Records Committee. You can't go to court. They have basically exempted themselves from all independent review. And so just be aware if you're going down that. I don't know if you've had experience with that, Eric. I usually haven't tried very often because it's such a dead end, and especially these days, they've just been saying no to everything. And there's really no accountability for that other than people saying, bringing light to the fact that they're not releasing their records. Now, that doesn't apply to someone like Reyes, which is why we were able to take him to court. But Annie Knox also asked for the calendars of Speaker Schultz and President Adams, and they basically said no. And there was really nothing that we could do because they essentially are the bosses of the people who are deciding their appeals, which anybody who knows anything about an independent judiciary knows that's not the way it's supposed to work, although apparently the legislature thinks that's how our judiciary is supposed to work. So it's tough. So if you can find, it's often the case that records are at multiple places. And if you can find a place that's not the legislature that might have the same record, it's worth that path instead.
Yeah, I was just going to emphasize that. My friend Lee Davidson, who was at the Desert News and the Tribune for a long time, he was the master of the federal counterpart, the FOIA. He was the Washington correspondent for many years. And his philosophy was he would file FOIA requests to several agencies he thinks might have it. And he often was very successful in getting each agency to respond. And then he would lay them out on the table. And one agency had redacted something and another agency had read something else. By the time he put it together, he had most of the documents. So sometimes it is wise. Now, I know that the legislature enacted something about making multiple requests and so on and so forth, but there might still be some strategy there, particularly when the legislature is involved. Maybe there's some state agency that also has the same record.
So Joel, I think you're also going to have to explain FOIA, much like we explained grammar.
Yeah, the night of alphabet soup. Freedom of Information Act is the federal equivalent of grandma. Don't you love this? And you can use them as a noun or a verb. So you can FOIA something or grandma something. That's how us journalists talk that use it. But no, FOIA is the federal equivalent. And so remember that grandma applies to state agencies, state created agencies. But if you wanted to go get something from Hill Air Force Base or from Bureau of Land Management or any sort of federal agency in our state or in DC, you would then file a FOIA request, which has a similar process. They don't have a FOIA committee, but they do have an ombudswoman in the federal level. So there is a similar process. Ours is better in Utah than the federal system, but there is that process. And I'm sure I'd be happy to talk about it or even have you, well, I'm sure Leva Davidson wouldn't appreciate me referring, but there's some people out there have done a lot of FOIA work.
And I'll just throw one other thing into the mix. This isn't technically on your list of things to talk about, but there's another category of open records that if you are doing, depending on what it is you're looking into in Utah, that's even more robust in terms of your right to get them, and that's judicial records. The records of the court system, both federal and state courts in Utah, are presumptively public, and unlike executive and legislative records, you have a constitutional right to access them. And it is much, much harder to keep records that have been filed in court cases away from the public than it is for an agency just to say, I find that this is, private and I'm just not going to give it to you. And so it just, you jogged my memory, Kathy, because there's that case obviously going on right now about the voucher, whatever the name is. I don't know. I just call it the voucher program. And there's a constitutional challenge that's being brought to that. And I don't know what kind of, I'm not involved in that case, but I know that there are some records that may be getting filed at some point in that case. And to the extent that you can do some sleuthing around, and it doesn't have to be that topic. If it's something else, you're looking around, there are online sources where, for a very small fee, you can access court dockets and download documents and do it immediately instead of having to go through a grammar request and wait a different period of time. So don't forget about that bucket, at least, of information.
That's good information. So we live in a digital era. Why aren't all of these records available digitally? I mean, that would be so much easier. And I know Eric has requested paper documents. Why aren't, and Joel has too. Why aren't they coming to us digitally?
Well, it's a good question, but a lot more records are digital and online than you might realize. And part of that kind of goes back to why it's also good to kind of have a dialogue with the records clerk, because they might be able to say, oh, actually that's on our website. Let me just show you where it's at. You're looking for a particular report. When the legislature tried to gut grandma was that 2011 and totally rewrite it, and there's immense pushback, and then they went back on it and apologized. They had a really good outcome of that was they said we should work on getting more of these records online, and I think there have been a lot of good efforts to get a lot of things online. Looking in the right databases, the Transparent Utah database, the open data portal, that there's been problems with that lately. There are a lot of records online, but a lot of the records that are probably not going to be just you can find them on a database are those things like email records. People are talking about something, or maybe kind of internal investigative reports about an issue that's come up. But a lot of stuff that's a matter of course, stuff that gets talked about at meetings, budgets, things like that. A lot of it's online. That's a topic for a whole other evening about how to access all that.
Yeah, but sometimes it might be worth it for the folks that are listening in. Transparent.utah.gov. That's kind of the place where it's resident. There's problems with it, but there are some good databases that have been put out there. And one thing I have been encouraged by, when I was a reporter back in the day, I covered Bountiful City, and I could never get a copy of the the packet that went to the city council members beforehand. It was delivered by hand by the cops the day before the city council meeting. And I said, can I get a copy of that? No, it's like, see, but today there is some things that are good about happening. Most cities now do have a place where you can go read the whole packet before they talk about it in a meeting, and it usually has very useful information. Most city councils are now recording their sessions and putting those up, as is the legislature. So I'd say in that area there has been some improvement. Yeah, it's just sometimes when it's maybe more embarrassing or it's a little bit more hard-edged request, that's when you might get some pushback.
Okay, Joe. Oh, sorry. Just real quick, I was gonna say in there too, like you're talking about public meetings and stuff. Like you go to like the Utah Public Notice website. I'll put that in there, utah.gov/PMN. I mean, that's a site like you can look at that to find meetings that are coming up, but I use that all the time to look up meetings that happened in the past. Because if somebody came and they did a presentation to the city council and there's documents and a PowerPoint. A lot of those documents, they all get uploaded to this website. You can go back and look at it. You can go back and find links to the audio and the minutes and stuff. That's a great database just to throw out there.
So will you tell us that database again, Eric? Or do you want to put it if you put it in the chat, we'll have that for later.
Yeah, I was just about to put it in the chat, but it's utah.gov/PMN, or you could Google Utah Public Meeting Notice.
Yeah, that's a great resource. It's really an improvement over the days when I had to beg West Bountiful City to send me I went and I gave them stamps in an envelope and said, could you please send me your agenda? And they okay, maybe.
Yeah, those were the days. I'd like to give you each a little time to sort of wrap this up, give us some final thoughts, tell me if we've forgotten anything, which I'm sure we have. I'd love to hear more war stories from you. Who shall we start with? Eric, would you like to start?
Sure. Yeah, I would just say, you know, requesting records, it can feel intimidating, but you gotta remember, these are your records. Like they belong to you presumptively, right? Like all of our funds are going into the creation of these records. You know, it's amazing sometimes how government agencies can so fully adopt this kind of us versus you mentality and feel like when you're requesting information about what they're doing, they feel almost offended that you want to know how they're spending your public monies. So those records are yours. Don't be ashamed to like ask for them, to fight for them if they're denied and you think it's done unjustly. And like I said before, like you should feel passionate and fired up about that, but you should know that like you'll be more effective in getting those records if you're polite and specific. And if you ever have like any questions about this stuff, like I love to hear about people's grandma battles and can help out. If anybody wants to reach out, I'd love to look at grandma responses, even help you file grandmas if you like. So they're your records, go after them.
Thanks, Rick. We have a comment here from Steve Van Maren. He said he agrees. More meeting packets are available to the public, but there are staff memos or administration communications to the council and shared comments that are not included for the public and seldom are included in the minutes. Has anyone run into that problem before?
Yeah, I think it does vary by municipality. As a reporter, covered Salt Lake City, and I felt like I was getting everything. I mean, I remember staff memos that would be for or against something. Now, on the other hand, I don't want to pick on Bountiful. This is many years ago, but still, it was very difficult to get any staff recommendations or background memos. But maybe that's if it's a really important issue, is like, they're doing rezoning or development or something, and you feel like you're not getting the whole story. I'd say that's when I would put a grandma request in for other information that's being shared with the city council or the city manager or whoever. I think you should ask for that. And I know sometimes it's not available, but maybe certainly on a big issue, I think you should ask.
So any other final words from you, Joel?
I would just say, Eric and I are the same, it's been a lifetime thing to ask for records, ask things. I was just going to share my kind of parting shot. One of my favorite reporters, his name was Don Baker. He was a legend. He worked at the Standard Examiner, ended his career all too short, died too early at the Deseret News. But he was my hero. He was kind of a force behind a lot of the work on grandma early on, and I witnessed that. I was a young reporter. He was a little bit older than I was, but Don, when he got to the end of his career, the only thing he wanted to do was cover city council meetings. So he'd like go to South Jordan. I mean, this wasn't like the big news, but he would go to South Jordan and he would have a stack of blank grandma forms. And by the end of every city council meeting, he would like walk up and give them like 10 grandma requests for everything they talked about. I mean, you don't have to do that, but to me, that's the kind of, we should be really curious about our government and hold them accountable. And that's always an inspiration to me. Thanks.
Yeah, I worked with Don at the Standard, and I'll tell you, he recorded everything and then transcribed. I think we must have gone through reams of paper with his transcriptions. Okay, David, on to you.
I'll just say I'm really gratified that all of you came to listen to this and are interested in doing this, because sometimes it does take an army of people to try and track down government secrets. They're in a lot of different places and everyone's not looking in the same place, and so it's really good. I'll tell you, I mean, if I mostly represent journalists in doing this type of work, but not all. And there's no reason that you have to be a lawyer or a journalist to do this work. The system is designed so that you don't have to be. And I'll just tell you one story about a case about a professor up at Weber State named Dan Schroeder. And he's just sort of a political gadfly and blogs in his spare time. He's a very interesting guy. But he got when he gets when he gets interested in something, that he's like a dog with a bone, and he was very tenaciously pursuing records from the Attorney General's office. This was back before Reyes was in office, so a little while ago. And he I can't even remember the subject of the investigation at this point, but it was someone who had been investigated by the Attorney General's office, and he was trying to get records related to them and was getting denied at every turn. And so he would call, and my firm runs a Freedom of Information hotline that's primarily for journalists, but I had known him from other connections, and so I was sort of helping him along. And this went on for a couple years, where every once in a while he would check in with me, and he made his initial grammar requests. He got some records, but he pushed and pushed, and then he took it to the Records Committee, I believe, and won. And eventually it ended up in district court. And he represented himself in district court. As long as you're not representing a company, you can represent yourself in court. And he went through all of the procedures there and lost in district court. And then at that point, we agreed to help him with the appeal to the Utah Supreme Court, which we did, and went up and won. But that was just the tail end of the story. All of the legwork had been done before by him, and exactly like the situation if any of you are not lawyers would be in. So it's possible to do it. You should not be intimidated by it. It's just sometimes you need a little advice along the way, which people who have done it before are usually happy to provide. And as long as you stick with it, try to be nice, like Eric said, get people on the phone. Try and make things so that, you know, both of your lives are easier, but persevere, because it's the vast majority. I'll tell you one very last thing, and this is to sort of this point about persevering. I had a case. This was, I guess it went to trial during COVID, so it would have been the late 2010s. And you may remember that there was a story in the news about jail standards. There had been sort of an outsized number of people who had died in jails, and in particular in Davis County. And the standards that jails used were used by a number of different jails around the state. They were written by this guy named Gary DeLand. And anytime a reporter or, you know, someone would try and get copies of what the standards were for the jail to see if they'd been violated when someone would die, he would send a threatening letter to them saying, I own the copyright, and so if you release the records, we're going to sue you. And there was a reporter at KUER, who sent a grammar request for the same standards to every county in the state. And I believe she got back responses from maybe half of them or less. And that's usually what happens when, and it's not necessarily because counties want, or, you know, entities want to stiff arm you. It's because a lot of times they just don't have time in their jobs, and they feel like if they can ignore it, then most people will go away. So don't. And by the way, at the end of the day, we won that case and got copies of the standards, but it took a trial. It took several years of litigation to do that. And so you don't need to be that persistent, but you do need to be a little persistent and make them understand that you're not going to go away just because they say, no, we don't give that kind of stuff out. And that just takes time, you know, and if you've got the time to commit to it, then there's no reason that you can't do what Dan Schroeder did and do what other citizens have done and get the information that you're looking for.
Well, I can't thank you all enough for participating. I think this was a really important webinar. We are just citizens out there looking for information, and we don't want to be intimidated. Thank you for offering to help. To remind everyone, this has been recorded. It will be on our website, lwvutah.org, with a list of the resources from all of our presenters. So thank you again, Joel Campbell, Eric Peterson, and David Reymann. Thank you.
Thank you.